There's no such thing as an easy divorce, but with mediation, it can be a little bit easier because parties have the ability to make their own decisions about what the outcomes look like. And it's a more efficient way to get a divorce in most cases. It's certainly a more cost-effective way to get a divorce in most cases. And to the extent that they are very personal decisions that need to be made, it can be a more gentle way to get a divorce for the people who are involved, who are changing the definition of their family and deciding on what things will look like when they're no longer living together in the same home. I'm Raina Brockman. I'm an attorney at Surratt Law Practice. I have been an attorney here for about 6 years. And I do most of the mediations that we get in our office. Mediation is a process where clients get to decide the outcome themselves. As a mediator, I act as a neutral. I'm not there to make decisions. I help give clients guidance as to what would likely happen with specific issues if they were contested in court or if a judge were to make those decisions. But ultimately, all of the decision making is made by the parties who are choosing to get a divorce. And so the most personal things in their lives: where do the kids live? Where do the kids spend time? What school do the kids go to? How should parties divide their things? How should parties divide their debts? All of those things in mediation, they decide themselves rather than having those decisions made by a third party, made by a judge. As a mediator, I act as a neutral. I am not there to make decisions for people. I'm not acting as an advocate. I'm just helping people come to their own decisions, negotiated in the shadow of the law. What would be a likely outcome if the issue were presented to a court, presented to a judge? With mediation, the parties have to be comfortable with one another enough to sit in a room together to talk about some difficult issues. They need to be able to have difficult and sometimes uncomfortable conversations. And certainly there can be a point in mediation where one party leaves the room or I leave the room and talk to one party at a time, but I try to keep everybody in the room together so that there's no misunderstanding that I'm aligned with one party over the other, because I'm absolutely not acting as an advocate when I'm a mediator in a mediator capacity. Neither one of the parties are my client. They are both my clients. It's different than a traditional attorney-client relationship where I am acting on behalf of one party. With mediation, all of the communication happens with both parties. I don't talk to one party without talking to the other, without the other one being apprised. All of the emails get copied to everybody. It's different than a traditional attorney-client relationship because I act as a neutral to try to help the parties come to their own decisions and make their own resolution, as opposed to advocating for a position, trying to get a win in court, as it were, if I were advocating on behalf of one party over the other.